Subscribe now and press the bell icon. Never miss an update.
Ready? Turning to the documents that are relied on. Those documents include extensions A22 and A23 valuation certificates of the gold allegedly possessed by the respondent's mother and wife, which were marked through PW4, A24 series and A25 marked through PW8 are the certificates issued about the properties allegedly owned by them. These are documents which were obtained after 24/3/2008 and are regarding the assets owned by the father, mother, and wife of the respondent plaintiff. The owners of these assets have not tendered any evidence whether they actually possessed these properties at the time when the agreement was to be performed, and even if they had possessed these assets, whether they were willing to part with it in order to enable the respondent plaintiff to generate funds out of it towards the sale consideration payable under XA1. There is also no averment in the plaint to that effect. In so far extensions A11 to A16 are concerned, these again are fixed deposit receipts issued in the year 2012, which also cannot help the respondent plaintiff to prove his capacity as on 24/3/2008 or any time before that. Among the other documents which were relied on by the learned counsel for the respondent to contend that the readiness was proved by him, Acts A17 and A20 show that his father had sold certain shares on 3/11/2010. Similarly, extension A18 shows that the respondent had sold his shares on 31/8/2010. Act A19 is yet another document which shows that on 26/12/2011 his mother had sold certain shares. Acts A26 and 27 are certificates issued by the Canara Bank and Union Bank again in 2013 when the trial was pending, which shows that his father had certain funds available with him, as in the case of Acts A11 to A16, A22, A23, A24 and A25. All these documents would not show that funds were available with either of the respondent or his parents on 24/3/2008 or any time prior thereto. Therefore, these documents also will not help the respondent to contend that his readiness and willingness were proved by him to substantiate his prayer for specific performance of Act A1 agreement. On the above reasoning, High Court allowed the appeal and decree of the trial court was set aside. We have heard Shri K.V. Vishwanathan, Learned Senior Counsel for the appellant plaintiff, besides Shri P. N. Ravindran, Learned Senior Counsel for the respondent defendant. Learned Senior Counsel for the plaintiff points out that High Court committed error in interfering with the judgment of the trial court. The principles relating to compliance with Section 16C, which enshrines the concept of readiness and willingness on the part of the plaintiff, has not been properly appreciated. He submitted that plaintiff had sufficient capacity, which is what mattered. The law cannot be disputed that in a suit for specific performance, the plaintiff need not have the amount in cash. What is crucial is whether he has the financial capacity to perform his obligations. He drew our attention to the fact that the plaintiff, along with members of his family, which consisted of his father, mother, and his wife, had enough resources. An amount of rupees 5 lakh was already paid. Even the gold ornaments, having regard to their value, valued at rupees 24 lakh, besides about rupees 8 lakh in cash held by the plaintiff himself, would suffice. The court need not even go into the aspect relating to landed properties and other assets available. As regards the finding of the High Court about the certificates relating to landed property being later in point of time, it is pointed out that lands were very much with the members of the family as on the date of the agreement and the date when the sale was to be executed. The fact that the certificates were of a later date did not take away the availability of these assets. He pointed out that in fact the dispute actually centered around the extent of property, and the financial capacity was not in dispute as such. Per contra, Mr. P. N. Ravindran, Learned Senior Counsel, drew our attention in paragraph 8 of the trial court, which we have already referred to. He further submitted that as regards the gold ornaments, the plaintiff has not chosen to examine the members of his family, and without their testimony showing their willingness to make available their valuables, apart from the availability of the assets, it could not be said that the High Court fell into error. Before we advert to the facts, it is appropriate to discuss a few decisions of this court. In Man Corps Debt by Lawyers versus Hartar Singh Sangha 2010, 10 SCC 512, this court dealt with the contention of the purchaser in that case that the vendor had committed the breach, and there is no need for the plaintiff to prove his readiness and willingness.
Subscribe now and press the bell icon. Never miss an update.